This is a talk about sort of liberal, classical liberal ideology, apologizing for capitalism, and going into this whole tradition and sort of resurrecting the inalienable rights tradition of the democratic movement and the abolitionist movement, feminist movement, and applying it basically to wage labor, to employment contract. So we have to, the idea is to take liberal ideology, the way they frame questions, and then see where the problems arise. So it's basically a talk about intellectual history and a talk about theory, high theory, but how to address the sort of dominant ideology of our age now, not only in the West now, but almost around the world. And as usual, the problems in an ideology don't come from the answers, they come from the framing of the question, how you frame the question in the first place. And the liberal framing is, well, it's a question of consent versus coercion. That's sort of the basic framing. And unfortunately, an awful lot of the left accepts that framing and then just says, well, it's not really voluntary in my high standard sense of voluntary. But that's not the way the issue is actually developed in intellectual history. This is where people have in the democratic and abolitionist movement, have developed theories criticizing contracts, even if they are voluntary. And that's the whole notion of inalienable rights. Rights are inalienable even with consent. So I want to get into that history, but the sort of liberal view is that political democracy is based on consent of the governed in the classical expression, and capitalism is based on consent as well in the employment contract, the principal contractual basis for the capitalist firm, the employment firm. And so the liberal picture is given to us by Sir Henry Maine that the progress of society is progress from status to contract, and status meaning slavery, feudalism, autocracy, and to contract, and contract meaning contractual basis in the political system and political democracy, and contractual basis in the workplace and the employment contract, wage labor contract. So that's the end of history. We've solved all the problems. Francis Fukuyama's famous phrase, and all that's left is sort of to clean up the details. And if the perfect system is not quite running right. So what could be wrong with this? What could be wrong, for example, with a truly voluntary contract? And not the one that fusses around the edges and says, okay, it's truly voluntary, but in some sense it's inherently wrong. So how can that possibly happen? And the part of liberal intellectual history that you don't hear about in the books is that the sophisticated defenses of autocracy and even slavery in the past was not based upon racism or not based upon divine right. It was based upon a contractual interpretation to their condition. So the political contract was essentially seen, and this is essentially since Roman time, was seen as a pactum subjectionis, a pact of subjection, where you went from citizen to a subject. And we'll see later on, like Thomas Hobbes was the classical version of that, but even slavery. And so you won't read about this in liberal intellectual history. It's like totally down the rabbit hole, and it's seen as a projection back of the basic liberal framing. Consent versus coercion, so therefore all the bad stuff in the past could not have been based on consent, it was based on coercion. And so they don't tell you this whole history, which I'll go a little bit into, but even modern classical liberal thought, and I'm saying classical liberal, everybody knows this doesn't mean American liberal, it means liberal in the sense of Hayek or neoclassical economics, the liberal in the European sense of liberalism, and in America often called libertarianism as well, sort of right-wing libertarianism. So Robert Nozick was the sort of principal intellectual father of this in more recent times at Harvard, and both approved in the ideal free society the political contract where you give up your rights of self-government to what he called a dominant protective association, and then said, and then quoting here, the comparable question about individuals, whether a free system would allow them to sell themselves into slavery, I believe it would. So here you have a Harvard professor, a very prominent philosopher, just died a few years ago, saying we should allow voluntary slavery, which was the sophisticated defense of slavery throughout the whole history of slavery in the Bible, Roman times forward. And of course, modern economic theory. If you look at the details of modern economic theory, the fundamental theorem is the theorem that in a competitive equilibrium, it's Pareto optimal, or allocatively efficient. So what do you mean by competitive equilibrium? Well, it means that all markets, all transactions where you have a willing buyer and a willing seller can take place, because if you have a willing buyer and a willing seller and they can't do their transaction, then you've got you can't be Pareto optimal. You've got a transaction that can still take place and both benefits, so the equilibrium cannot be Pareto efficient in the usual sense of you can't make anybody better off without making somebody worse off. So the principal market we're talking about here is the market for future labor. And so if you don't allow long-term or lifetime labor contracts, essentially voluntary slavery contract is a lifetime labor contract, then you're shutting off certain markets. So if I have a demand for labor 20 years in the future and I have a supply of labor 20 years in the future, and if we don't validate that contract, then we cannot have an efficient equilibrium. So the real theory, which you won't read about in the textbooks, is as this gentleman here, the second quote, is actually from congressional testimony, believe it or not. Economist Carl Price, who's quite a famous econometrician at Johns Hopkins University, who lays it out. And he's not being ironic or being critical here. He says we have to have complete future markets in labor, and that means we have to allow people to sell or mortgage their persons in return for present or future benefits.
Roughly when was that, David? Do you have any idea when his testimony was?
It was in the 70s.
In the 70s. Okay.
So the other thing which is interesting, talk about false consciousness. If you go to Europe and you rent a car, you'll find that it's called hire a car in England. It's a hire car system, and nobody thinks that that's something fundamentally different than a rental car. Everybody understands that renting a car and hiring a car is the same thing, just sort of difference between British and American usage. But and everybody knows what it means to hire a worker, but when you say rent a worker, then everybody gets, what do you mean? You don't rent people, so forth. But in fact, it's exactly the same relationship, the rental relationship. You're not buying the person, you're buying their labor services, and that's the rental relationship. So I give a quote here from two of the principal textbooks, and the main neoclassical textbook, of course, is Paul Samuelson's classic. And he, in other places in the book, says quite explicitly that we have the rental system. We rent the workers, and you can't buy workers. That would be slavery, but you can rent them. And the second text here is a little more recent. Fisher, Dornbush, and Schmalensee. Fisher was the chief economist of the World Bank and number 2 man at the IMF for a number of years. Now he's the head of the central bank in Israel. When they retired recently. Dornbush was a macroeconomist, now deceased. Smolensky was my roommate freshman year at MIT, and he may be sticking it to me by putting this in his book. Yes, we have a rental system, and we're proud of it. So I don't know, because it's even more explicit than in the Samuelson text, so. He's a professor at MIT now. So anyway, the system we're talking about, hired labor system, is basically the system of human rentals, and I use that phrase deliberately to sort of get people to think anew and not just sort of fall into the old linguistic habits of thinking about that. And what's interesting is that you have a system where a philosopher, not to mention Nozick, but John Rawls, the sort of modern progressive philosopher at Harvard, lived his whole life in a system based on human rentals. And if you're a plumber or electrician or something and you live your whole life in a system based on human rentals and you don't quite realize it or you don't write about it. But here's a guy who's a philosopher writing about the theory of justice and his entire life, never even conceptualized the institution of human renting as a problem. Okay, apologize for it, but at least recognize it might be a problem in renting human beings. Never did. I mean, this was just like invisible to him. And so what you get is, as I said in the last bullet there, you get a lot of fussing about the quality of the consent, the coercive background conditions, exploitative wages, dangerous working conditions. And this is like, you know, a critique of slavery where slaves are mistreated, not a critique of slavery inherent to slavery, but of sort of bad conditions. And that's the best you got out of John Rawls and the like, and I'll say a little bit more about him later on. So what is the real debate? Reframing is the real debate is really in the consent side. Of course, consent is a necessary condition, but there are actually two fundamentally different types of contracts, which historically in the Latin are called concessio or translato. And the translation contracts, translato, is where you give away, you alienate your fundamental rights, your person or your fundamental governance rights, and so forth, versus a concessio contract, the contract which most delegates the exercise of some decision-making power to a governor, a representative, or a trustee, or a manager, and so forth. So the real debate was really between these two different types of contracts. And as we'll see, the rise of the democratic movement and so forth was to restructure or reinterpret the traditional pactum subjectionis, the traditional pact of subjection, not as a contract of alienation, but to reinterpret it as a contract of delegation, saying that the king is really our delegate, and then that has all sorts of implications through it. And we'll say a little bit about that intellectual history. But this is actually the real debate. And the theory that was eventually developed here was that there's something inherently wrong with the alienation contracts, the translato. And this sort of reframing of the issue is absolutely unavailable to liberals. You will not find this in any liberal book because the reason is obvious. The employment contract falls on the wrong side. Nobody thinks the employer is a delegate or representative or a trustee of the employees. So the employment contract is obviously an alienation contract. So if you cut the cake this way and you say this is the traditional debate that the democratic movement, abolitionists and so forth had to deal with, then you have failed your job as an economist to account for the system, or political theorist to account for the system, because the employment contract, the basis for the system, is on the wrong side. So if you want to see this dichotomy in the intellectual history of literature, you have to move beyond liberals at least to civic republicans. The Quentin Skinner is his 2 volumes on the foundations of modern political theory are quite good, and he constantly hammers on this distinction. And so he's a Republican, civic Republican thinker, and is quite real to us about the servility involved in the employment contract, and he can recognize this. But the same people, just to give you another example, I think I have a slide on later on, but there's a fellow, Jonathan Israel, at the Institute for Advanced Study. He's written book after book after book on the Enlightenment and the whole intellectual history of the same period, and totally misses this. Totally misses it. I mean, it's just like it's a blind spot, and that's just why it's a blind spot, because the fundamental basis for our economic system is on the wrong side of the dichotomy. So you cannot frame it that way at all. Now let's go back and look at some of this history that you won't read in any liberal intellectual history. And it's the critique of slavery, of course, by liberalism, is that it's coercive. So the whole history of voluntary slavery, the whole sophisticated defense of slavery on the basis of being voluntary, is something just unavailable to them, doesn't fit into their intellectual framework at all. And we can start with the Bible if you want. There's in the Bible, there's a whole thing that says after the Jubilee period, Hebrew slaves have to be set free. But if the Hebrew slave says, I will not go out from you, then there's a whole ritual they can recommend where they become a permanent slave in the household. And in fact, the ritual is where you take an owl, a sharp pointed, and you stick it through the earlobe into the door frame. So the symbolic of you're now part of the furniture, I guess, is the symbol here. And so that's in the Bible. But the real beginning of sort of Western jurisprudence was in Roman law. And the Institutes of Justinian were one of the principal codifications of Roman law. And they gave 3 reasons, 3 ways in which you could legally become slave according to Roman law. And one was an explicit contract. People over the age of 20 could have an explicit sell contract. But the principal one was what we would in effect interpret as a plea bargain, is where you have committed some crime which the Romans considered a capital crime, so they have the right to kill you, but they're willing to talk. You want to plea bargain this into a lifetime of servitude, fine. And so that was the principal source of Roman slaves, was the captives in Roman wars, and they had committed the capital crime of resisting the Roman wars, and then you would plea bargain into slavery. So, and then the third reason was if you were born of a slave mother, then you've got 18, 20 years of food, clothing, shelter, and you need to work it off. And so it was like this is more like a debt peonage interpretation, but the same thing, that you need to pay that off. And of course, it's as you pay it off, you still incur more debts to the master, and so it becomes a system of debt peonage. And this was, if you look through then the more recent than Roman time, the natural law, natural rights philosophers, Grotius, Pufendorf, Suarez, all were quite explicit that you own your liberty like your property, and therefore you can sell it like your property. And this comes right through now in modern libertarian thought. If you go in any of the libertarian books or libertarian websites now, you'll see this concept of self-ownership, that people own themselves, and it's essentially an idea that you own yourself, you own your liberty, and you're born with this natural right to debt, but if you want to sell it, well, that's fine. And so it's a idea that has come right down from Roman. Law. So what about John Locke? Well, John Locke is really the central figure here in the intellectual history of liberalism. And so how did he stand on this whole theory of voluntary slavery? And so first of all, he was quite okay with a voluntary contract, a real contract. We'll see later on that he objected to the form of the contract where the master had the right to kill the slave. But if it was just a matter of civilized contract where the master does not have the right to kill the slave, then as Locke says there, he's fine with it. And that's but he wouldn't call it slavery, call it drudgery. And we had this in the Bible and so forth. So this is the founding father of liberal thought, basically, and he's the one that set the thought patterns that have continued to this day in liberalism. And so from Locke to Nozick, they had no problem with a truly voluntary contract for slavery. And Locke also accepted the plea bargain argument. This is the second argument in Roman law. And so if you want to read that little passage, or I won't read it to you, but basically says that if you've done something that deserves death and you want to postpone the death by plea bargaining for condition of being slave, that's fine. And if you ever change your mind, then just resist your master and you'll then get the death you deserve. So, and Locke, of course, wrote the Constitution for the Carolinas over in the New World, and which were all involved slavery. And the principal idea there was that the slaves were these prisoners of war that had done this plea bargain over in Africa, and then they were sold by a series of contracts to America, and so that the people that owned the slaves in America had obtained them through a bona fide contract, ultimately from prisoners of wars in Africa, and then they had children, and the children were then legally slaves by that third reason, born of slave mother. Now, here is a quote from somebody you also won't find in liberal intellectual history. This is one of the more liberal defenders of slavery. In 1861, published this book called American Slavery Justified by the Law of Nature. And he really was a very, his grandfather, I think, was the founder of the Presbyterian Church in America. And he was more famous for this. So he gives you a quite explicit thing here that wherever slavery exists as a settled condition, there is a explicit or implicit implied contract, and the people consent. And then he imagines the reply contract. Where's the contract? How can you say the master and slave are bound together by a contract? And then he says, well, okay, how about the social contract? Where did you ever, or your fathers ever sign a social contract? He said, oh no, it's an implied contract. The society has. He said, well, this is the same thing. So he gave you a basically a liberal implied contract justification of slavery in the antebellum period. Now, what's of interest here is modern treatments of pro-slavery writers. And I challenge you to look at any of the anthologies of pro-slavery writing that you have now in the history departments or wherever. They don't know Seabury, and they just sort of ignore him. And example is this one by Eric McKittrick, Slavery Defended. So this is sort of this anthology of 17 different writers from the antebellum period. So anybody who was a racist or feudalist or had all these things that tried to defend slavery for illiberal reasons, they get reproduced there. But as a liberal defender of slavery, it doesn't exist. And so I've been able to find no compendium of pro-slavery writings that include Seabury as an example. So once again, you get this very narrow, that certain things were just not allowed to, don't fit into the liberal configuration of what intellectual history is, and so the liberal contractual defense of slavery just doesn't exist. It's not available to modern scholars to look. Yeah. Now that's the individual. The political version of that, the social version of that, is of course these political contracts of subjection, and that also started. Well, we can go back to the Bible, but it's more reasonable to go back to, again, the Institutes of Justinian, and this is the passage that is much quoted. Is the Lex Litigia, that the Roman people by the Lex Litigia have given up their imperium, in other words, their right to govern to the prince. And so this was interpreted, of course, as a contract of alienation, that the Roman emperor was hardly a delegate or a trustee of the people, but it was contractually based, that this was the Lex Regia. And you see Aquinas saying the same thing, that not some crude divine right theory, but the government is based on the consent of the governed, and as Quentin Skinner points out there, this act is an alienation, not a delegation. Just that analysis of Aquinas saying it's an alienation, not delegation, you will not find in the liberal text. This is Quentin Skinner, who's a civic Republican, and so it comes out of a different tradition. Of course, the epitome of classical pactum subjectionis is Thomas Hobbes, and giving this whole argument that life is a war of all against all, and unless we give up, each gives up this power to govern to the sovereign, then it will constantly be this life of a war of all against all, where life will be nasty, short, and brutish, and so forth. So the interesting thing here is Hobbes wrote before Locke. Their lives overlapped a little bit, but Locke knew well that Hobbes had written. So if Locke took on Hobbes, then he would have had to say what's wrong with the voluntary contract if he didn't want to agree with that. And Locke just ignored Hobbes. just completely ignored him and chose someone who had a whole theory of divine right. The Filmer, his theory of patriarchia. So there's our Father in heaven, and then there's the Father on earth, which is the monarch, and then there's the Father in the family, the patriarch. So you had this natural order of authority all the way down, and consent had nothing to do with it. So Filmer was the perfect foil for Locke's thing that government has to be based on the consent of the governed. So the last person that Locke wanted to recognize was Hobbes. That was also, here, consent, based on the consent of the governed, but a complete dictatorship in Hobbes. And then you see that tradition culminating in Harvard's Robert Nozick, who I quoted before. So this is the history leading to modern times. And here's an example, something that's quite recent. And so we all have these interactions with sort of perfectly normal liberals or progressives, or whatever. And it turns out that liberalism has no direct connection to democracy, really. The point is, democracy is great because it's based on consent. But you could have something else based on consent. You could have a non-democratic government based on consent, and that's this idea of a charter city. So this is usually associated with Paul Romer, a pretty well-known development economist. Used to be out of Stanford, made some money in Silicon Valley. Now he's at NYU, and his big idea is that if you build cities with the right laws, legislation, legal framework, like Hong Kong in the old days, then that will be the key to development. So you will go around all these corrupt governments in the third world and developing world, and by building these new cities. And the new cities will be new, so they'll be built cities. And when anybody comes to them, it has to be the voluntary move there, so you're not imposing this on existing population. Then by that voluntary move, they will be giving their consent to whatever the governance arrangement is in the city, and they're not democratic. The governance arrangements is some corporation or even some foreign government, and with some nice liberal economists like Paul Romer, or there's been a few others that joined with him on committee. This almost came to pass in Honduras recently. The Honduran government, remember, they threw out the elected president in a coup, and then they shortly held new elections where the elected president wasn't allowed to come back in the country and run again. And the guy that got elected then was quite agreeable to a contract where basically part of the sovereignty of Honduras would be given over to this charter city arrangement, and this corporation, we think it's probably Canadian money, or not quite sure where the money was coming from. It was hardly a transparent transaction, but it almost happened until it went to the Supreme Court in Honduras, and the Supreme Court threw it out. So now the government is trying to throw out some of the judges in the Supreme Court to get the whole thing reversed, and so it'll be unclear whether we're going to get a charter city in Honduras or not. They tried one before in Mozambique, it didn't work. There was a whole attempt to do it in Georgia, the former Soviet Republic of Georgia. And so what's surprising is that you'll get like ordinary liberal economists. I mean, Paul Romer is not a libertarian. He's just sort of a normal neoclassical development economist sponsoring this whole idea where democracy has absolutely nothing to do with it. Another version of this is rather than try to carve out a chunk of sovereignty in some third world country, let's do it in the ocean. Let's have a water world. Remember the movie Waterworld, Kevin Costner? Well, this is the grandson of Milton Friedman. Milton Friedman's son, David Friedman, is the son of Chief Friedman. And so his idea is seastead. So it's the homestead idea, but at sea, so you have a sort of a city formed by all these houseboats locked together.
Do it right out there.
And if you disagree with the government, then you just unlock your houseboat, unplug it, and go somewhere else, join another city. So the consent is given by you coming there, and you're always free to exit. Nobody is roping you into this. So that satisfies the liberal criteria of government based on consent to be governed, but this is obviously an alienation contract. So this is big in libertarian circles. And this may come to pass too, because now there's a plan. There's so much trouble getting high-tech people from India to get these visas where they can work in Silicon Valley, that the Seastead people are now working on this plan to have a Seastead city off of San Francisco, which will be populated by these high-tech workers from India. And then you'll have the internet connection to Silicon Valley, and then you have these short-term tourist visas where they could come in for a day or two or whatever. So this may actually happen. Economists that are just ordinary liberals don't have a problem with this. I mean, this is because it's all based on consent. If you go there voluntarily, then what's the deal? The three movements that we're sort of tracing here are the abolitionist movement, the democratic movement, and here is the similar contract in the feminist movement. It's the old style marriage contract. And here I'm quoting William Blackstone, the fellow that sort of codified the common law in England. And the coverture marriage contract, the legal language is from the French, the coverture. So the idea is that the married woman is under the coverture of the husband. And the legal phrase is the husband and wife are one person in law, and the one person is the husband. So that, yes, women can own property, can make contracts, but in the name of their husband, sort of as an agent for their husband. So their independent legal personality is extinguished by the coverture marriage contract, and of course it was extinguished when they were beneath age. So the idea is that a woman grows of age and then gets married and passes from the cover of the father to the cover of the husband. And even though this contract is, of course, now outlawed about the end of the 19th century, I mean, it's not outlawed in Saudi Arabia, but it's outlawed in the West, we still have the vestige of this in our marriage ceremonies. I mean, what's the father gives away the bride, and that's exactly the vestige of the coverture thing, where the woman passes from the cover of the father to the cover of the bride, and what happens to her last name? The last name goes from the last name of the father to the last name of the husband. So we still have all this vestige, and people sort of act like they don't know where all this came from, but this came from the coverture marriage contract, which is also called the Lord and Baron relationship, and the woman was called the femme couverte, the covered woman, and the anomalous thing was a femme sole, a woman who was not covered, who was of age, so was no longer under the cover of the father, but was not married, and so was not under the cover of the husband, so she was an anomalous creature, like a masterless man in the feudal times. So anyway, the three principal applications of voluntary contracts that are now outlawed are the voluntary slavery contract, the pactum subjectionis, and the coverture marriage contract. And what we're going to see basically is that the theory as to what is inherently wrong with these voluntary contracts also applies to human rental contract, and which is why this theory is unavailable in liberal intellectual history. But if you look at a recent modern book by liberal thought, say, oh, we have a theory of inalienable rights. One of the recent books that's got a lot of twittering going on is John Tomasi's book called Free Market Fairness. So it's sort of a remix of Hayek and Rawls, is the best way to describe it. And he's the head of the political theory project at Brown University, and so he's trying to get in the free market theory of Hayek, but at the same time some of this alleged concern with social justice in John Rawls. And he says, oh, we have a theory of inalienable rights. So I have to go over the false theory of inalienable rights, sham, I should say sham theory of inalienable rights that also comes down from John Locke before we can look at what the more serious theory is. And I mean, Locke was absolute genius in setting the thought pattern for liberalism. So he not only gave the thought pattern for the labor theory of property, the thought pattern for democratic government based on consent, and even the notion of inalienable rights. Locke had a version of that. So his idea of a contract that could not be allowed was one where you gave up the right to your life. So the master legally had the right to kill you, and then you can justify that however you want. They give it a theological that God owns your life, and so you can't give it up, or whatever it was. But the sort of classical example, classical horror story is some Roman senator who killed the slave to feed his goldfish, and so that keeps repeated in the literature. And so if you had made a contract that you could become fish food, then that was illegal. That was inalienable. That's beyond the pale of liberal thought. But as we saw before, I quote again, Locke, after giving this strong statement here, then does this pirouette and says, oh, if it was a true contract with consent and so forth, then it's perfectly all right. We don't call it slavery, we call it drudgery. And that thought pattern, that is repeated all the way down, including John Rawls, as we'll see. This became the mold for liberal thought. And so let's look at Blackstone himself. This is the principal codifier of English common law and thus jurisprudence to that. So here you'll have the strong statement that slavery, where it's an absolute and unlimited power, in other words, the power over life, the power to kill the slave, that's ruled out. And the famous statement, the Somerset case, the instant he lands in England, he's a free man. So you think, oh, well, this is great. And Blackstone was against slavery and so forth. But then you read a little further, and you see Blackstone does the same pirouette that Locke did. It's about, it's just a matter of perpetual service for a John or a Thomas. Then that's just like a apprentice or a worker where you have 7 years, except it happened to be for a longer term, for a lifetime. So Blackstone had no problem with the civilized contract for lifetime labor, but not one where you gave up your right to be killed by the master. Montesquieu. Montesquieu is another one of the founding fathers of liberal thought, and Montesquieu gives this argument to sell one's freedom is repugnant, and that freedom is beyond all price to the seller. It's not quite what kind of argument this is, because obviously when people did sell themselves, it was because they were starving or whatever other reason that did it. Their life, their freedom did have a price. But the interesting thing is that Rawls quotes Montesquieu. Rawls plays the same game, the same Lockean pirouette that we see from Locke and Blackstone and in Montesquieu. And you see Rawls even quotes the same phrase here, the beyond all price, down here, that was in Montesquieu. And then, of course, you've got to read a little further in Montesquieu to see the pirouette. So here's the pirouette in Montesquieu. You read a little further down, and he says, well, what I meant by slavery was strict slavery as exists among the Romans. That's where you had the right to turn the slaves into fish food, and that's present in the colonies. But there is a true and rational origin of the mild law of slavery. So this is the civilized form of slavery, where the master doesn't have these rights to abuse the slave. That's okay. That's fine. And that's a mutual benefit of the parties. This is neoclassical economics. It's a mutual benefit of the parties. You can't rule us out in a competitive follows right along and says, well, you can't alienate all your rights, all the basic rights, but if you want to alienate some of your basic rights, then that's all right. And this is the passage. The basic rights are inalienable does not exclude the possibility of alienating some rights in a well-ordered and just society. So this goes right down, from Locke right down to John Rawls. So I'm not criticizing some extremist here like Nozick, the guy across the hall. John Rawls at Harvard had the same view in a more moderate form. So let's now go back and resurrect, find this more serious theory of inalienable rights, and it was really developed in the abolitionist movement and in the democratic movement. And it goes back, at best, to the Stoics and the idea that slavery was only slavery of the physical body, that you had a soul that was sui juris, that was a law unto itself, and that the inner part cannot be delivered into bondage. So the sort of idea that in some sense we are free in our will and in our thoughts was back there in the Stoics. Even though there was no abolitionist movement in the Stoic times, I mean in the ancient times, ancient Greece, they have almost no history of any abolitionist movement back in those days. And the great modern historian of anti-slavery thought, David Bryan Davis at Yale University, has a famous phrase, something like, in ancient times, sin was a form of slavery. So they refer to it, if you are a slave to your passions and all that, then that's their idea of slavery, and that's what the Stoics, of course, or a Stoic even today represents, that you're not a slave to your appetites and your passions, that you're above that. And then David Bryan Davis says, only in modern times did we realize that slavery was a sin. So sin was a form of slavery in classic time, and in modern times slavery is a form of sin. So nice expression. So the modern abolitionist movement, really the serious one, really goes back to the Reformation and to the idea of liberty of conscience. And so the idea here is that in some sense I cannot, and this is not, should not, this is cannot, I cannot alienate my decision-making power about my religious beliefs to the Pope. I cannot give that over. At best I can say, well, whatever the Pope says I'll believe, but that's still you saying I'll believe it. It's still you ratifying it. So in some sense that this is going back to the same idea of the Stoics, that your will, your internal will is sui juris in some sense, that only the body is a slave and you can be controlled bodily, but that your will is still in a certain sense free. And so here this idea reemerges in history with Luther, and you can read the quote there. I mean, there's this proverb, thoughts are free. So this is what is called liberty of conscience, that we cannot give up our, in the Protestant Reformation, our right to make theological decisions to the Pope. That each man is priesthood, priesthood, and you have to read the Bible, and you have to make your own decisions, and so forth. So this idea, where this idea re-erupted in history, became then the seed that was turned into the theory of inalienable rights. So primarily Spinoza in the Dutch Enlightenment, Radical Enlightenment, and then Francis Hutchinson. So here I give you the quotes from Spinoza and Hutchinson, and in my title I said rights inalienable even with consent. So even with consent here is a quoting out of Spinoza. And So he, even though he was Jewish and an atheist, he was the one that picked up this idea from the Reformation and turned it into a theory of inalienable rights, basically. And that we cannot, these things are natural right. But unlike the other natural rights, which were seen as a form of property that you can alienate, here is a natural right that you cannot alienate even with consent. And notice, this is not like a moral recommendation. He's saying cannot. So that's very important. That this is, you're saying human beings have this internal freedom, and these contracts pretend that it doesn't exist, that it can be ignored, that you can be treated as a piece of property. And so this idea re-erupted is that we cannot alienate even with consent. And we'll see, of course, that you can have a legal system that will recognize a contract of alienation and enforce it, but it's always a bogus contract because we cannot, in fact, alienate this control over ourselves the way we can a piece of property, a hammer or a shovel or something like that. Now, Spinoza, of course, he wrote before Hutchinson, and they both wrote in Latin originally, but Spinoza was a bad guy. Spinoza was atheist and a Jew, and so a good, upright, pious person like Francis Hutchinson, who was the father of the Scottish Enlightenment. He was the teacher of Adam Smith at the chair in philosophy at Glasgow, where Adam Smith eventually became that chair. He could not quote Spinoza, but I'm sure, by sort of textual evidence, I think that he basically got the idea from Spinoza, but of course he couldn't quote this horrific guy over in Holland, so the thing comes back into Hutchinson, and this is the mainstream. This is where the American colonies didn't like British thought or English thought. They liked Scottish thought because the Scots hated the English the way that the colonists did. So Hutchinson had a great influence, and this is where it got introduced into the Declaration of Independence through. Jefferson, and here's Gary Wills, great modern intellectual historian, political writer, in his book on Inventing America, which was timed a little bit after the bicentennial of the Declaration of Independence, saying Jefferson got it from Hutchinson. So that's the sort of trajectory there. And once it got into American sort of political theology, then everybody forgot what it meant and just quotes it on 4th of July. And it doesn't have any significance, or because when you see the whole theory, you see it also applies much more strongly. Somebody like Stalin Lim, of course, understood this, and before he got kicked out of his job at Yale as a historian, he wrote this incredible book, Intellectual Origins of American Radicalism, and he correctly identified this as the idea coming down through the Reformation, this whole idea of the mind's quest for religious truth, and this was not like an ownership thing. It's not like self-ownership you read about on a libertarian website. This was part of being human, that you cannot give up this free will, this making decision. You may ratify whatever decisions that somebody else makes, like the Pope, but it's still your decision. You should be responsible for your own views, and that's the liberty of conscience. And so Hegel is another, gave one of the clearest renditions of this theory of inalienability, and he's talking about slavery here. And I think Hegel's important to quote here because Marx basically missed this, and yet it's in Hegel. So Hegel basically says that when we sort of take possession of our own subjectivity, then we have we can no longer treat ourselves as a piece of property, as a res nullis, something that you can, like a shovel, you can use and then give up take your will out of it, as it were. You can't take your will out of yourself, but you remain a responsible person, and therefore this essence of your self-consciousness is inalienable, and the right is indescribable, which you can't lose this. So Hegel really had understood that tradition very well. So this is the basic idea now. What's going on here? So what is? Remember the original question: what can a truly voluntary contract? How can a truly voluntary contract be inherently invalid? And we now can see that you can have a contract which puts a person in the legal position as if they didn't have this, as if they were a thing, or they were a person of diminished capacity, as in the case of the coverture contract, or a person without capacity, as in the slavery contract, or the pactum subjectionis, a person without self-governing capacity. So the legal contract says that, but of course the whole point, I said, is the factual thing that people cannot give up. They still have to make their own decisions. You see that idea coming right through from the Stoics through the Reformation, Spinoza and Hutchinson. So, but doesn't mean a legal system can't validate such a contract and say, well, so since I actually can't become, the married woman didn't actually become a child without capacity, or the slave didn't actually become a beast of burden, what do? Well, the law says, okay, we'll accept your part of the contract as just fulfilling, obey the master, obey your husband, obey your master, obey your employer, whatever, your king, whatever it is, and we'll call that your part of fulfilling the contract, but it's a legal contract, therefore your rights are the rights as if you were a person of no capacity or diminished capacity. So this is a perfectly contract can be and is now, in the case of the employment contract, accepted. And this sort of surrogate performance is accepted as fulfilling your part, even though that's not what's going on. You in fact are not a non-person, you're not a person of diminished capacity. So it's basically a legalized fraud, fraud sort of on an institutional scale. And so the point here is not that people should not alienate their responsibility or their human capacity, is that they cannot, but that the legal system can certainly recognize a contract which says, okay, you've given this up, you signed this alienation contract, we'll accept your obeying the master's fulfilling it, but now your legal rights are, as are specified in the contract, the legal rights of a non-person, the legal rights of a person with diminished capacity. So that's the game. So the normative critique only comes in saying, oh, you can't have a system based on legalized fraud. Really, the contract cannot be fulfilled. It's an impossible contract. So it's inherently invalid, and yet historically and even today, you see such contracts where the legal system will validate it and say, obey the master and we'll consider your part done. So the moment of truth here, the sort of the intuition pump, is to look at what happens when a slave, say, or employee commits a crime. See? Because the contract, if you take slavery as being based on a contractual situation, then the contract is that you're a non-person, and non-persons cannot be responsible for crimes. You're a beast of burden in the case of the slave. And yet, if you go back and look at the jurisprudence in the antebellum South, this is a quote from a judge in Alabama back in the 1850s, slaves are rational beings, they're capable of committing crimes, and reference to those acts, they're persons. So you have this shell game going on. If you commit a crime, then suddenly you become a person, but insofar as you have just performed acts that are not illegal, the civil acts, then you're a thing. So you've broken free of the factuality of this slave being a person, and you say, okay, as long as you're obeying your master, then not committing a crime, then you have the legal rights of the thing, namely none. But if you commit a crime, then suddenly you burst into legal personality, and we're holding you responsible for the crime. And that's exactly the same thing now with the master-servant relationship, with the employment relationship with the laying people, whatever you call it. So here I'm quoting from a British law book, which still uses the master-servant relationship name, and says all who participate in crime with a guilty intent are liable to punishment. The master and servant who so participate are liable criminally, not because they're master and servant, because they're two people that jointly carried out this criminous act. So that's so the reality, the fraud of the normal contract erupts to the surface when they commit a crime. Because even the legal system says, hey, you guys are not things, you're not some employed instrument, you're a human being that decided to obey your master, to rob a bank or commit a murder or whatever it was, and you're responsible too. So they recognize the factuality of the responsibility, and since they then say, okay, but we don't consider the employment contract to cover this, so we're going to hold you legally responsible. So the fraud is really out in the open. It's not like some secret analysis where you just look at the treatment of the right criminal. And of course, when the hired worker doesn't commit a crime in a normal production, they're just as factually responsible as before. They don't suddenly become robots when their actions are not illegal. So the whole fraud here is just So now let's go back. So that's the slavery and rental version of the contract. Let's go back to the intellectual history of the political thing. And as I mentioned before, the rise of democratic theory was this idea that we need to reinterpret the social contract as a contract of delegation, not of alienation. And that seems to have gone back to the Middle Ages, late Middle Ages, and this is Otto von Guericke. He was writing at the end of the 19th century. The book was republished in 1966. But these are the two schools. So this is the alienation and delegation school. So the alienation school was we interpret the contract as a transilato imperi, the alienation of the right to govern, as a definitive and irrevocable alienation. And the other school, the delegation school, interpreted as a concession on the use and exercise. So you're setting up a representative or a delegate or a trustee sort of relationship, and not an alienation. And the two people that are usually credited with making this flip in the interpretation of the social contract are Marsilius de Padua and Bartolus of Saxo-Ferrante. These were late medieval political writers in Italy. And of course, it's Clayton Skinner, once again, that second quote there that nails this down. And you'll see in his two-volume Foundations of Modern Political Theory, this is being spelled out. And so this is one of the quotes where they gave this interpretation that it was really a contract of delegation and not a contract of alienation. So here's Ernst Cassirer giving the same sort of a critique, referring to the great logician, which is of course Hobbes, and saying that if you have a contract, a political contract that pretends to alienate your right to personality, to be a person, then that's a bogus contract with contradiction in terms, et cetera, and therefore the contract is invalid. So that's the history of that political contract. And as I mentioned before, Jonathan Israel is a good example of a literal thinker, and the classical sense, and not being particularly libertarian, but just an ordinary liberal thinker, even in the American sense. And he's got all these volumes that have been very well received, and full of erudition and detail and everything. and just totally misses it, just completely misses the whole alienation versus delegation, and just unavailable and to him. So, so the question there is why is he blind to all this? Well, he's blind to, of course, because it applies to the foundation of modern liberal society, which is the renting of people, the employment contract. So you can view the employment contract either as the individual version, rental version of the self-sale contract, or you can view it, particularly when it's collectively bargained, as a sort of workplace pactum subjectionis. And no one thinks, even the most servile intellectual thinks that the employer is the delegate of the employee.
It's the what?
Delegate.
Representative of the employee. So it's absolutely sharp. This is no fussing about consent here. This is a sharp distinction between a contract of alienation and a contract of delegation. It is a contract of alienation. You transfer the right to self-government within the confines of the employment contract, within the confines of the workplace. And, of course, we know you can't actually transfer responsibility in the factual sense, as we see from the hired criminal, that when the law recognizes that the employee being the employer is still a responsible person, and nobody wants to argue or can argue that people suddenly become robots when their actions become legal. So the fact is that you have the same de facto responsibility in the workplace when the employee is not committing crimes. But so how do you interpret the contract? Well, you say obey the employer. You don't say, well, you have to actually become an employed instrument, a rented thing, but we'll apply that contract to you and we'll count your performance that will validate the contract. You just obey your master, obey the employer. And as long as the employer doesn't tell you to commit crimes, which then, as it were, bust you out of that contract, then that's your part. The employer's part is to pay your rental payments, the wages, the salaries, and that's it. That's the whole contractual system, the basis of the system. We see in the case of the servant in work becomes the partner in crime when the law intervenes to actually look at the de facto factual responsibilities. Says, okay, you're two human beings or more who cooperate together to commit this crime. You're all responsible for it, and that so they assure then that they appropriate the fruits of their labor, in this case the negative fruits of their labor. And since no one argues that they become robots in normal production, then the same moral principle there would apply, that people should appropriate the fruits of their labor, positive or negative, in normal production. And that's what historically is called the labor theory of property. And that's a different talk to analyze all these things from the point of view of the labor theory of property. But here we're looking at it from the contractual point of view, the bogus nature of the renting of human beings contract. And then same thing, doing it as a political contract, not an individual rental. And so as I said, nobody can plausibly argue that it's a contract of delegation. And then when you look at this from the point of view of corporate governance, you've got this incredible idea that somehow the corporation, the members of the corporation are these shareholders. And occasionally you'll get somebody who will have the bright idea, well, actually that's not, the shareholders are not the people that are governing corporations. People working in the corporation are those that are governed. So the whole analogy with shareholder democracy doesn't quite hold. Here's Abram Shays, who's a professor in law school at Harvard, sort of spelling that out. He doesn't go anywhere with it. He just sort of says, actually, this is not a very good analogy. And yeah, it's not a very good analogy. And why don't we carry your thought a little bit further? He refrains from doing so. So if you rethink the whole question of structure of corporations, this point of view, then basically the argument is that the whole contract of renting people, even if it's purely voluntary, is invalid. And that the whole idea of capital hiring labor is thus invalid. That's a contractual basis for capital hiring labor. So the only contract that can be the basis for work-based governance is where labor hires capital, or already owns the capital. And that's basically the worker-owned firm, or workplace democracy, or worker cooperative, or whatever language you want to use. And here's one example of a chap who's no radical. In fact, he's a British lord, 1944, and basically recognizes this. The whole idea of this corporation we don't recognize the true firm, which is the people working in the firm that produce the property, and instead we recognize this artificial association of shareholders and creditors, and that we should give the law to the real association, withdraw meaningless privileges from the imaginary one. So even someone with no sort of radical background and all that is sort of, in a moment of clarity, says we should really reconfigure corporations. This is the great urgent challenge to political invention after the war, to reconfigure corporations as human associations of the producers and the people that produce and distribute the wealth. So this idea erupts occasionally in the normal literature, and I've tried to sort of give you the whole background to this thinking. Now the interesting and much more controversial part of this is that, remember I said in the beginning that this is all in the framing, that if you frame the issue as one of consent versus coercion, then you miss the real debate, which is all on the consent side, between the consent to alienate and the consent to delegate, the two different types of contracts. And unfortunately, and I'm not trying to get into sort of Marx exegesis here, but what has come down to us as Marxism is essentially one that doesn't challenge the framing of capitalism, but just takes the other side of the issue, that says, yes, it is a question of consent versus coercion, but it's not really consent. It's a weak form of consent, and I have high standards of consent, and people don't really have a viable alternative. They don't have a guaranteed minimum income or something, and therefore the consent is a bogus form of consent. And so they accept the framing, number one, and argue that it's not really voluntary by some high standard of voluntariness. If you look at the contracts, then the contract that consumers make has much less freedom to it than a collectively bargained labor contract. In a collectively bargained labor contract, you have some give and take. All consumer contracts are contracts of adhesion. You don't sit there and bargain in a supermarket, and so forth. So this part of Marxism is sort of doesn't understand the actual theory of inalienable rights that came down through the Reformation and is even there in Hegel, quite explicitly in Hegel, as I showed you, and instead just quibbles about the consent. The consent is not really true consent. And of course, the liberal thinkers love this because they know that this is, from the judicial, jurisprudential point of view, is perfectly a valid consent. And even the definition of the system, even the name capitalism, see, I've assumed from the get-go here that the characteristic feature of the system is the rental of human beings, not the private ownership of capital. You obviously have privately owned capital in Union Cab or Isthmus Engineering and so forth. That those are not government-controlled firms. And so the key thing here is the role of the workers. Are they self-governing, or are they giving up their rights in a rental contract? And Marxism doesn't have that framing. The very name capitalism, which is mainly popularized by Marx, is it's based on private ownership of the means of production. So that's two of the major framing questions. Another major framing question is the whole analysis of the labor contract in terms of quid pro quo. Are the workers exploited? Now, if you go back to this critique of the labor contract, one thing I never mentioned was the wages. I never said how much was given to the workers. It has nothing to do with it. The fact is you can't transfer your responsibility. And so it's not that I do transfer my responsibility, but I don't get paid enough. So the whole idea of a theory of exploitation based on the size of the wage, whether you're fully paid for your labor time expended, blah, 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 is a misframing and a misanalysis of the contract. It's like saying, you know, slavery is wrong if the slaves aren't fed enough, or the slaves aren't given good enough food, clothing, shelter. And has nothing to do with it. Slavery is wrong for quite different reasons, and renting of human beings is wrong for quite different reasons, and nothing to do with the size of the wage packet. So Marx said this whole thing about, well, the contract is fair in the realm of exchange, but if we follow me down into the hidden abode of production, then we'll see that there's exploitation taking place and workers are underpaid. And in terms of theory, the capitalist apologetics said that value theory, price theory, is the domain of contention, and Marx took that on. Marx tried to develop the labor theory of value, not the labor theory of property, labor theory of value, and to take them on and show that there was still exploitation, even though it appeared to be a bona fide exchange in the sphere of exchange, not down in the hidden abode of production where more labor time is extracted than was paid for, et cetera, et cetera. So in all these issues here, the Marxists have accepted the bogus framing of capitalist ideology and then have taken the alternative point of view. If you go back to the intellectual history of the time before Marx, you did have an alternative tradition. It was sometimes called the Ricardian socialist. People like Thomas Hodgkin, people like Proudhon, who wrote about property. It wasn't labor theory of value, it was labor theory of property. And the name of Proudhon's book was not What is Value, it was What is Property. And Hodgkin's book was about the natural versus the artificial right of property, compared and contrasted. So you had this whole tradition focused like a laser on the theory of property, and Marx avoided that and tried to take on capitalist economics as a theory of value, and with unfortunate results. We lost that battle a long time ago. So in some sense, what I'm saying here is that when you look at the intellectual landscape of capitalist apologetics, the real story is in how the questions are framed, and Marxism ends up playing this historical role as the people on the other side that accept the framing and just take the opposite side of that framing. All these four things I've mentioned here, for example. And so that's how the argument keeps getting rephrased, is the alternative is Marxism, and Marxism is against private property, capitalism in favor of private property. In fact, the whole system is based upon ripping people off with fruits of their labor, the very moral basis of private property. And as, the consent issue, the exchange versus production issue, the pricing of labor, as well as the whole battleground of is the value theory, is the property theory. And so the point here is that Marxism has become a tool, a part of the whole system of apologetics. And with the collapse of communism in the 90s, late 80s and the 90s, we have a crisis now in liberal apologetics that the population of Marxists is thinning, and so we need to recycle a few surviving ancient Marxists to play the role in the Bill Moyer show, or on even on Democracy Now! Or Charlie Rose, so they can now have these represent the alternative and to the system, and in fact that's all within a hugely misframed debate. So that's the end of my story here, and so we looked at the basic liberal framing. We looked at the retrieval of these contractual offenses that you will read about in the liberal literature. We saw the real debate, which is unavailable not only to liberal but also to Marxists. was between these two different types of contracts, both of which are voluntary, but one is inherently fraudulent and the other not. Retrieval of the inalienable rights theory, which basically descends from the anti-slavery movement, the abolitionist movement, and the democratic movement, and which shows that these personal alienation contracts are inherently invalid, and these three types of contracts are now all abolished in the more advanced countries, not talking about Saudi Arabia, but the same theory applies against the employment contract as well, and that's why the theory is not available to liberal thought. Thank you.